Hello and welcome, and thank you for attending today's Atticus webinar, 10 Ways to Improve Your Initial Consultation. Today's presenter is Steve Riley, an attorney and Atticus practice advisor. Before we begin, there are a few logistics I'd like to go over with you. If you are not familiar with Atticus, we were founded in 1989 to provide in-depth, ongoing support and accountability programs for attorneys that effectively help you increase your revenues and your personal income, help you reduce stress and the number of hours you spend in the office, get a greater sense of career satisfaction, and allow you more time for your family and personal interests. If you happen to have a question during the webinar, there are a couple of ways you can send that to us. The first is to use the chat function on your GoToWebinar dashboard to send a message to the event organizer. That's me, I'm Mike Wells. If you'd like your question to remain anonymous, you can indicate so in your message. You can also click the hand icon to indicate you have a question or comment, and we'll call on you. When we do, we'll unmute you so that you can be heard. Today's presenter is Steve Riley. Steve helps attorneys grow their practices, and he's a shareholder in Atticus, the largest practice management company working with solo and small firm attorneys. He helped create the Practice Growth Program, the Dominate Your Market Program, and the Double Your Revenue Workshop. He's written 7 books and won a national award for practice innovation and written a national column on practice management. Steve, thank you so much for leading today's session. It's an important one, and I know that everyone on the session today will get a lot out of it.
Thanks, Mike. So welcome to the call, everybody. I have a co-presenter today that I'd like to introduce as well. So we have an attorney and adjunct practice advisor with us, Mark Metzger. Now, those of you that have, so welcome, Mark, welcome. This is a real treat for me because not only is Mark a good friend, but Mark is a very skilled estate planning and elder law lawyer who's really, since working with us, has increased his revenues 5 times and has been so good at this that we've asked Mark to actually start teaching programs. So Mark is leading, he's completed his first program. He's now leading a new program that's the Practice Growth Program. And he sold out his first program, so we've opened up a second program. So those of you listening to Mark and would like some more exposure to Mark, he is leading a new group that is starting in February 22nd, 23rd, and 2018, and he'll be leading the Practice Growth Program. And his prior group sold out. And if you're saying, well, look, Steve, I really don't want to come to Orlando to work with Mark, even though you say he's terrific, we have a San Francisco program starting in May that's led by Patrick Wilson, who's been with the company for 15 years, who's a excellent practice advisor. But those of you that are in the estate planning and elder law field, what makes Mark so unique is that he's an estate planning elder law lawyer. He's got, while he's got an amazing element to his practice that's doing real estate, he's built a heck of an estate planning elder law practice. So with that, Mark, welcome to the call.
Thank you, Steve. It's good to be here.
So I just want to talk for a minute about the Practice Growth Program that you're leading, so we can set up a context around this, if that's okay with you, Mark.
Sure.
So when we talk about the Practice Growth Program, there's really 4 elements of practice, really the 4 cornerstones of growing a practice, which is helping. When lawyers start to grow their practice, they really think the most important thing to do is to become a better lawyer or a greater lawyer. And the 4 elements of critical business skills to grow a practice are really learning how to shift your time and focus management, learning how to develop clients, really how to make a profitable practice, and then building and staffing a great team. Today's webinar on 10 ways to improve your initial consultation really hit all 4 of these cornerstones. We're going to talk about how to improve your time management through efficiencies and effectiveness in your initial consultation. I don't think we could talk about a more critical component of client development than improving your initial consultation. We can talk about profitability, pricing, and cash flow throughout the entire presentation today. And those of you that are looking at integrating your team into this process, you know, it really supports building a great team. Mark, anything you want to say about this before I give a shout out to the Practice Growth Program a little bit further and then dive into the presentation?
You know, I think you hit the magic button on all of this, which is that without a successful initial, none of the rest of this even comes into play.
Perfect. So for those of you that want to know more about the Practice Growth Program, in particular, the one that Mark is leading, we are going to have Mike Wells post for you a link so you can check out the program, the testimonials to the programs, the videos to the programs, the dates to the program, your investment in the program, all the logistics to the program. Since today's webinar is really not about the Practice Growth Program per se, it's about 10 ways to grow your, 10 ways to improve your initial. I want to make sure though that I gave you the opportunity to look at the Practice Growth Program, in particular, look at working with this amazing instructor, the Mark Metzger, on today's call. So great. So here's our agenda. We're going to dig into why is this so critical. Mark and I are going to talk about the 6 different types of initial consultations that we have seen in the estate planning and elder law field, which if you're not clear about, can really mess up. So if you're not clear about which type of consultation you're adopting, if you apply these principles to your consultation, you're not clear about which one you're going with, it can throw you off a little bit. And then if we have time, some bonus point programs. So why is your consultation so important? Mark, what do you think?
Well, it's the front door to the money, right?
Perfect. I've never heard you say that, but that's brilliant. It's the front door to the money. It's also the front door to creating customer expectations, because from that point forward, every promise that you make has to be delivered by your production team. So every promise that you set in the initial has to be absolutely critical.
You know, Steve, there's an interesting adjunct to that, which is there are unspoken promises that we make to clients that we deliver on in initials too. You know, if we're conveying through the website and through things we say and otherwise do that this is a first-class experience, and somebody's left to wait in your lobby unattended to for 5 to 10 minutes, and then somebody strolls out, and 3 or 4 people stroll out over the course of time, say somebody helping you, and that's a horrible experience. If the client is greeted by name when they come, and they're told that they were expected, and they're ushered into a conference room, and they're offered a menu of available beverages, and they choose one from that. I mean, you're indoctrinating them with the idea that this is a first-class professional services operation, that they were expected, that they were anticipated, and that all this is just in the normal course of affairs.
Perfect. That's absolutely perfect. So what I'd like you to do, you're attending the webinar today. We have over 100 people here today with us. I would recommend, and we have from a variety of different places, Mark. We have people that just attended the Double Your Revenue workshop and the How to Build for Sale last week that was sponsored by Wealth Council and Elder Council. We have some Elder Council and Wealth Council members that are clients of ours, and some Elder Council and Wealth Council members checking us out. And then we have a whole group of lawyers that are estate planning and elder law lawyers that work with Atticus. And then we have a whole group of lawyers that are checking us out, that are trying to figure out whether or not Atticus might be a good investment for them long term. So we have a really interesting smattering of lawyers all over the place that are joining us today. What I'm going to recommend, though, just for a moment, we're going to give you about 30 seconds to do this. I'd like you to take 30 seconds, and I really want you to write this down. I don't care if you type it or handwrite it. I'd like you to take a moment and ask yourself, where is the #1 place that I am stuck in my initial consultation right now? So just take a moment and kind of get present to that. Just write it out, type it up, whatever works for you. Of course, if you're driving, don't do that, but I'd recommend you to write it. Even if you're listening to the replay of this later, or if you're not in the estate planning elder law field and you're listening to this later, literally write it down, because it brings the problem to the front part of your brain where your prefrontal cortex is at, and it will help you start to problem solve. Okay, great. Let's go ahead and talk about the 6 types of initials. Mark, if it's okay with you, just because of time pressure, I'm going to whip through these real quick.
Sure.
But don't hesitate to interrupt me and slow me down if I'm going too fast. So these are the 6 types of initials. The first one I call the classic, and this is the one where the lawyer rolls into the meeting with a yellow pad. It's typically a 2 to 3 hour consultation, sometimes known as the show up and throw up, where the lawyer is trying to impress the client with everything they know about the law and has no real conscious thought process about what their business process is to educate the client. I also like to call this one the hostage negotiation, because sometimes after 2 hours, the client knows the only way out the door is if they hire the lawyer. And so they hire the lawyer as a way of getting out of the meeting. And then consequently, they call back the law firm and say, hey, look, I've been thinking about it, I've changed my mind, or whatever they may have to say about that to kind of get out of that. So the number one is the hostage negotiation. Mark, anything you want to add to that before I jump to number 2?
No, but I think that's very common.
Yeah, I agree with you. I think 75% of the ones that are out there are where lawyers walk in with a legal pad. They haven't thought about it. They may have been doing this initial for 10 to 15 years, or this is how they learned from somebody else. There's no real conscious thought to how to improve it.
What scares me too about one that's that long is I don't know how you're in a meeting with a client that long and not giving them legal advice. And even though they haven't hired you, you're now their lawyer.
Yeah, excellent point. Number 2 is the traditional 2-step. This is where the lawyer combines the initial consultation and the design of the estate plan or elder law plan or the crisis plan, whatever it may be. And then they do a delivery process separate. So I see this is probably the second most popular one. Then the one that we call the 3-step shuffle. This is the initial consultation where it's a separate initial consultation meeting. And then the strategy or design process is separate. And then they have a delivery of that process, whatever the production may be later. The third one is the swing. And the swing is where there's an initial consultation, design meeting, delivery of the process, and then if we're doing estate planning or maybe proactive Medicaid planning, there's a funding of the assets or implementation of a Medicaid crisis plan, and then a delivery of those documents that support the assignment of ownership. Mark, anything that you want to add to that before I jump to 5?
Well, I think that, well, no, go to 5, and I think we can have a wrap-up comment.
Okay. Well, I have 5 and 6 that I'll do, and maybe you want to hit both of those afterwards. 5 is usually when a practice has got a very good volume and their marketing is doing really, really well. And this is where the lawyer creates a new client workshop or new client video or educational event because they can't handle the volume. They're getting too much business in the door. So they discover that the best way of pre-educating and pre-qualifying clients is through a new client education workshop, a video, or some kind of education event. From there, we then see the initial consultation process, the design meeting, the delivery meeting, then the funding and design and funding delivery. Probably the most interesting one, this is the one that I've taught a lot of lawyers to do, and it causes all kinds of controversy when I teach this one. I get threatened to be burned at the stake with this one. This is the one where you have a non-lawyer do the initial meeting. And you can totally do this if you comply with certain things that Mark and I will teach you in a minute. And the only thing the lawyer really does is the design. The lawyer provides judgment, expertise, and strategy on the design of the plan. You have a delivery meeting, a funding meeting, and then a funding delivery. So all of these with the number 6, which we call the Gangnam style, is really centered around multiple meetings, but with the non-lawyer initial probably driving the uniqueness of this one. So Mark, you want to add some comments to this?
Yeah, I think that with the exception of number 6, which is a deliberate plan that's been put in place from the beginning, that's designed to work a certain way, the first 5, I think if you try to lock into one of those, you might be making a mistake, because unless you're in number 6, which is a pre-designed plan of sequence of the interactions that the prospect will have with the law firm that lead to the decision to engage or not engage, the other 5 are different ways of getting to the engagement. And I think if you're not cognizant of the different options that are available, with the possible exception of 1, which is not a good strategy, that's one of those things that people do because they've always done it, as opposed to they're doing it on purpose. but 2, 3, 4, and 5 are all potentially valid approaches. But I think if you're going to choose to go that way, you need to be paying careful attention to what the prospect is telling you and adapting a style to what their need is instead of trying to wedge them into what you want to do.
That's perfect. That's perfect. My experience is that I think you nailed it. Number one, the show up and throw up the hostage negotiation consult is probably the majority one they see most estate planning and elder law lawyers do, because they're kind of unconscious at the business. They haven't taken a step back and thought about their process. They haven't thought about their prospect pipeline. They haven't thought about their pricing. They haven't thought about all these things, and they kind of roll into it. The next, 2, 3, 4, and 5 are where the lawyer starts to get to a little bit more sophistication on all the business elements of their practice. 6 is probably the breakthrough, both for time management, pricing, and in my experience, most lawyers that have a non-lawyer do the initial, they never go back. Once they get a non-lawyer in there and they realize how empowering it is to the client, prospect, and team member, they usually never go back from that.
I think
go ahead, I'm sorry.
I was going to say, if you are adopting a 3-meeting model and you have a client that comes to you, for example, in the context of a financial advisor referral, they're probably heavily pre-sold to begin with. I've walked into some of those meetings and they don't want to have any discussion about how this works. They said the financial advisor said I should come in here and have you draw up a trust. And if you're going to be locked into a 3-step model, then you're going to have to be explaining to these people why they're going to have a 5-minute meeting with you and then come back in another week or 2 for a design meeting. You need to, I think, have the flexibility of saying, okay, we're jumping right to meeting number 2 then. So.
Yes. So there's a lot of, we could probably get that Mark and I could spend a whole amount of time just distinguishing and talking about comparing and contrasting the benefits of the 6 types of initials. What we'd like to do is dive into the 10 ways, regardless of the 6 types of initials that you have, that we think that you could look at to improve your initial. So as you go through this, kind of use it as an audit to check on how well you're doing your current initial and take away 1 or 2 ideas at least that you could do to perhaps improve it. So this is number 1. Number 1 is pretty much what I consider the 5 critical P's that should be in every initial consultation. Number 1 is being present. One of the things I really notice is most lawyers do is that if they've done 10 consultations or 100 consultations or 1,000 consultations, after a period of time, they kind of lose the capability of being present to find out really what's going on for the client. 2 is permission. One of the most powerful questions that I teach lawyers, and Mark and I both use the question, is the following. What is the most important thing? No, excuse me, the permission is, do I have permission to talk to you directly and go right after the critical issues? What are the most important issues that you really want to talk about? A lot of lawyers waste time talking and trying to develop rapport. And my experience is the client's already pretty much pre-sold on you, and a lot of the courtship around rapport and fact-finding is sometimes torturous to the client and a waste of time. If you're having to do a lot of fact-finding and education, that usually means you haven't thought through your education process prior to your initial problem. And the problem is really from the client's perspective. Process, what's your process to solve the problem? And then price, what's the client going to invest with your firm to solve those problems? Mark, anything you want to add to that before we jump to number 2?
I can't underscore enough the importance of being present. And it's not just a matter of making them, so putting on the airs. What's the Woody Allen quote about, once you learn to fake authenticity, that's everything? It's not about faking authenticity. It's about actually being engaged in the conversation with the client so that they feel that you are connected to them and their problem. And when you do that, doors just open.
Yeah, Groucho Marx has a great quote that's similar. It's like if you can fake, what is it? If you can fake honesty and sincerity, you got everything. Everything else is secondary. Basically, got it made. So let's go to number 2. Being prepared. Mark, why don't you take the lead on this one?
Well, I think that if you walk into an initial without an engagement letter and or some method that confirms how you're going to get paid, for example, the credit card authorization form, you're losing an opportunity. Some of the lawyers I've worked with have described their initial as a pretty good set of the P's, a discussion they're going to have with the client that's going to lead to an engagement where at the end of the meeting, the client says, well, I'd like to hire you. And then the meeting breaks up with the promise that the lawyer will then send them an engagement letter later. I think that's a huge mistake because you're giving them the opportunity to go out and change their mind. And the engagement letter alone may not be enough to cement the relationship. If you take full or partial payment, and as a side note, I know that, Steve, it's important to you that lawyers rethink the way they get paid. A lot of lawyers in the estate planning and elder law space have adopted a model where they take half up front and the other half when they deliver the documents. But there's really no reason you can't and shouldn't be getting paid everything up front. But regardless of which path you take, when the client has signed an engagement letter and they now know they have a lawyer and they've invested money in that relationship, the likelihood that they're going to go home and talk themselves out of it is dramatically diminished.
That's perfect. That's perfect. You're on fire. You want to talk about number 3 for a moment?
Buckets. Well, I learned about buckets from you. So the slide text is explaining a trust through the bucket story, and this is about using stories to engage the listener. And this is a technique that I use. In fact, I use the bucket story. So if you're not familiar with this, this is a technique for describing trusts to lay people that Steve came up with. And my personal version of part of it goes, think of a trust like a bucket. Now, you're used to buckets that hold water and paint and sand and whatnot, and we use them because it's a more efficient way of dealing with those things. You can only hold so much of that in your hands. And a trust is like that too. It's a bucket that holds assets or money. It's really nothing more than that. It's a set of rules that says how we're going to affect the money or the assets that are in that bucket. And what I've learned after using that description, and it's a little more longer and a little more flowery when I share it with clients, is that when they start using the word bucket back to me, I know that I've fully engaged them and I'm usually going to get hired.
Yes.
They're following my thought process on that. So that's a clear signal that I can get. If you're going to go down this road, and you don't have to go with bucket, you can go with any kind of analogy that makes sense to you, but it is critical for your law firm that whatever story it is that you're going to tell to describe this, it could be Russian nesting dolls, it could be a nest of boxes, it could be whatever. But what you can't have happen is the lawyer in the initial saying, well, a trust is like a bucket, and then the paralegal that they meet with for funding later talks about how it's a set of Russian nesting dolls, and the associate that returns a call while you're on vacation says, well, your nest of boxes, in referring to the trust. You have to adopt a firm standard for what we're calling different things when we're using our stories. So if you're going to go with buckets, then everybody needs to be using the description of bucket. And probably the best single reason to do that, by the way, is when the client calls after you've got them fully engaged and they say to the paralegal, I'm calling about my bucket, the paralegal better know what they're talking about.
Yes, perfect. So this is Mark is really gifted at being a terrific storyteller. So if you're looking at working with Mark or going to his practice growth program, you'll get an incredible dose of using, stories and marketing. The 2 elements I'd like to add to this, Mark, is that if you're, the real point of this is most of us as lawyers are using stories, but we're not conscious of them. So first off, get conscious of the stories you're using and make sure the story has a point. A lot of lawyers will tell stories just to trade stories, but not really realizing some of the stories they're trading don't have a point. And then make sure, just what Mark says, your team is using the stories consistently, because you can't have 4 different stories. The beautiful and talented Valerie Peterson, the CEO of Elder Council, uses a piggy bank story to describe a trust. So whatever you're using, just like Mark says, make sure it's consistent throughout the firm. Let's use to number 4. Mark, would you like to take the lead on this one, since you're firing away you're doing great. I think I almost should I drop off the webinar and go have lunch? So go ahead, bud. I'm sorry.
Visuals are important. The overwhelming majority of the people who we're going to meet with as prospects are visual learners, which means that graphical information and graphs and charts and pictures help these people understand things more effectively than just listening to words or just looking at tables of numbers, for example. if you decide that you want to start incorporating visuals into your initial discussion, the advice that we have for you is you don't just want to be scribbling these things out on a yellow pad or a whiteboard unless it's kind of a unique one-off thing and you're trying to help everybody understand something that is unique to this individual conversation. If you're really going to use visuals in the context of furthering the story that you're telling and emphasizing and helping the client understand what an option is, or educate them about different sets of options, have your marketing people pre-make some visuals for you and then laminate them and use them over and over and over again. One of my colleagues in the Dominate Your Market program that I'm a member of has an entire ring binder filled with laminated example sheets of various different things, and depending on how the conversation goes, he flips to the page, pops it out, and gets the laminated sheet out that has the graphical explanation of whatever topic it is that's currently being discussed, to help the client understand and get educated about what it is that he wants them to know. Pictures and diagrams are great, but unless you're an artist, you want to think of you drawing it as the option of last resort. To the extent you're able to conceive of these things in the first place, give the rough sketch to a marketing person and let them turn it into a proper diagram or a drawing.
That's perfect. If you don't have a marketing person on staff, you can always outsource it to a graphic artist, and there's a half dozen places that you can go to do that. But it really gives you the capability of saving time and effort for the client. It makes you look like you know what you're doing when you have something pre-drawn versus whipping it out on a yellow pad saying, oh, well, this is like the first time I ever diagrammed this. It doesn't look like you know what you're doing if you've got to kind of create it on the fly. And then appreciating, I think Mark said this really well, appreciating the fact that as attorneys, we're trained to communicate we're trained to communicate verbally and in writing, but majority of the population's trained to learn visually. So we have to, anything that you can do to reduce a communication barrier to the client hiring you and understanding you is an important hurdle to jump or eliminate.
Visuals are also a great place to work permission conversations back in, that second P, because you can say, can I have your permission to show you a graphic that may help with this? And that it helps build your muscles to get you used to asking that question.
Perfect. Absolutely perfect. Let's talk about number 5. I want to make sure people have enough time to ask any questions they may have at the end. As Mike well said, if you've got a question, we'll take probably 10 minutes towards the end, depending on how we do with the 10 improvement ideas. So next one is an agenda. And Mark, would you like to talk about the importance of having a written agenda during a consult?
Sure. If you set an agenda and you share that with the prospect when you start the meeting, you're setting their expectations of how the meeting is going to go, and they will not be putting you in the position of trying to get you to answer questions that amount to giving them legal advice. Now, contrast that to the unplanned initial. That's, I think a lot of lawyers initially start to do their initials this way. They just walk in and do the initial from the seat of their pants, which is why they end up in a hostage negotiation trying to show how smart they are. And they turn it into a stump the chump kind of exercise where they walk in and say to the client, so what would you like to know? What can I help you with? What questions can I answer for you? That's open season on them asking basically the question ultimately, well, what should I do? Which is the ultimate legal advice question. If you have an agenda that says to the clients, we're going to talk about this, I'm going to get this background information that I need to get from you, so that I can understand what direction you're going and I can make some recommendations about how to proceed and discuss our process for solving that problem, process being another P. You have a much better chance, because you've managed that conversation up front, to keep yourself out of those awkward questions where client is asking you a question. You say, well, I can't really answer that because then I'd be giving you legal advice. If you find yourself having to give that kind of an answer, probably what happened is you did not correctly go through the agenda process with them and set their expectations of how this meeting is going to work.
That's excellent. The agenda is crucial, and the agenda allows you to do a couple things really well. First off, it allows you to set the tone. It allows you to protect your time, the client's time or the prospect's time, and allows you to get clarity around the questions that you need to ask. I think Mark's point is very insightful. It's amazing how many lawyers walk in and this question, and I'll say the question, and and probably 80% of you will be offended by this, so I apologize. I think the worst question you can ask when you walk into an initial consultation is like, what brings you here today? Or what can I do to help you today? Because it's too open, too general, and it's not a really great strategic question. I really think a better question is, what's the most important thing that you want to talk about today? What is the critical thing that concerns you the most? Because then it focuses their mind to the most important issue in their mind versus a wide open question saying, let's talk about your feelings and how do you feel about this? And you know, it's amazing the range of issues that lawyers put prospects through that are exhaust them. They're really there because something's stressing them out. Let's go to the stressing out issue, whatever that might be, and help them work through whatever that issue is, and you know, help them. That's really why we're there. Let's switch to number 6, pricing. Do you want to talk about this, or you want me to talk about this?
Go ahead.
So this is probably one of the hot topics. That's why Mark's kind enough to let me to talk about it. I love talking about pricing, and I love getting our lawyers and all of our programs to think about pricing differently. I could probably do a 2-day workshop just on how to talk to prospects and clients about pricing your services. Easy. But there are 3 key elements that I'm going to hit on in your initial consultation. First, I'm going to recommend that you need to be talking about pricing somewhere around 50% of the way through, at the outside 75% of the way through. So if you have an hour budgeted for this, I really want you talking about pricing about 30 minutes into the meeting. Now, if you're not able to talk about pricing 30 minutes into the meeting, I'm going to invite you to look at everything that you might need to improve up to the initial meeting to pre-educate the client pre-educate the prospect prior to the initial meeting. Because a lot of lawyers, what they do is they wait until the meeting's over or close to over. They've run over time. They're bumbling into the next client appointment or prospect appointment, and then they just fling some kind of mood pricing out there and hope to God that they create enough value or enough relationship or enough rapport in the past, however long they were with the prospect, to get them to become a client. So I really want you to think about, if you're going for a reinvention or an improvement of your initial, how do you move the pricing conversation up? 2, I'm with Mark 100% on this. If you don't have an engagement letter, I'm going to invite you to really rethink that, because I want you to have an engagement letter that clarifies the expectations, what's included, what's not included. And I'm going to recommend, if you've never done this, this is something I think is like a stage 1 pricing strategy. If we did 100 pricing strategies, I usually can't get you to really cool things like pricing contexts, add-ons. I can't get you to do anything cool with your pricing unless you have at least a simple price list. And this is a must-have for me in any elder law and estate planning practice, quite frankly, in any practice. But this talks about what are your basic price points for your basic services. I usually recommend that you have one by practice area. So if you have elder law proactive, I would make sure you had one for elder law proactive. If you have estate planning as part of your practice, you have one for wills, you have one for trusts. And if you have crisis planning, I suggest that you have a price list for crisis planning. I don't get too deep into this, but I think it's a absolute must-have if you're taking your initial to the next level, to refine it, decrease the time, and increase your price points and profitability in your initial. Mark, I know there's a lot we could talk about here. Is there anything that you want to hit as a highlight?
Yeah, I would invite you to also consider not only having a price list, but whatever price list or lists you offer in the client's presence, that they be laminated.
This is a great point. Mark, why should they be laminated?
Well, I think there's 2 reasons. There's probably an endless number of them. The first reason that comes to my mind is it puts to rest the demon voice in the prospect's head that says, he's just making this up, this is negotiable, he thinks he can rip me off, and I don't want to be ripped off. And clients fear the possibility that you're ripping them off and that they're paying more than everybody else pays. So when you present them with pricing that's encased in plastic that costs you 3 cents to melt onto the page, somehow that signals to their brain that you didn't just make this up, this is the price that everybody pays. And that demon gets put to rest very simply and very easily without anybody ever addressing it by name.
I love that.
The second thing that happens is it gives you the opportunity, and this only works if your personality lets you get away with saying these kinds of things. Mine does. But on the rare occasion, and for me, it's maybe 1 out of 30, clients will be presented with price sheet, and maybe 1 out of 30 will look at me and say, "Is that negotiable?" I just chuckle and say, "Of course not. It's in plastic." And they laugh, and what's that?
I know we can. It's been laminated. Once you laminate these prices, they cannot be negotiated or changed. It does create a real impression of permanency in the prospect's mind. So if it's a very simple marketing technique or a very simple marketing strategy, but if you haven't laminated your price sheets and you have one, go ahead and laminate them. If you don't have a lamination machine or you can't order one off of Amazon, take it to Office Depot or one of those types of stores, and they have lamination machines. They'll charge a buck maybe to laminate it, or a couple of bucks, whatever it is, but it's totally worth the investment. Great, let's move on to 7. I'm going to talk just a little bit about this one, Mark, and then
Sure.
You pile on whatever you think I miss, okay, or add on whatever I miss. One of the challenges, and this is a very, very difficult challenge with a lot of lawyers that may do complex work for people that aren't used to doing complex work. So these are, probably elderly folks or affluent folks that aren't used to doing, complex estate planning or complex asset protection planning. I usually recommend on complex cases, rather than going for one large price tag, which I call bundled pricing, to break it into small bites, into stages or into phases of engagement. That way you can give the client a lower price point where they can test you, try you out, and build their confidence around your ability to deliver what you promise. So if you're having a difficult time on complex estate planning or complex Medicaid planning or anywhere that you feel like it's complex, my recommendation is move away from a bundled pricing model where one price covers everything to an unbundled model where you break down your pricing into several different price points. For me, this is probably a really big secret to unlocking what is perceived by most lawyers to be a complex planning area. Now, I don't want to spend a lot of time on that today on the webinar because there's a lot of different ways that you can do this. But I want to say that if you're getting stuck in your initial on complex cases where on complex processes where it looks overwhelming to the client, unbundle it. Do a stage 1 price, a stage 2 price, a stage 3 price, and a stage 4 price. So this is one of the things that when we do a lot of programs with Elder Counsel, I recommend lawyers when they first got into crisis planning to do a feasibility study on qualification and charge a lower price for that versus a significant price to get someone qualified and apply for Medicaid. Same thing can be applied to complex taxable estates or to asset protection. You can do a feasibility study or what I used to call an asset protection report. You can do things that will allow the client to get a sense of the strategy that you're recommending at a decent price point. Normally, most lawyers have a fear, well, if I give the client my strategy and explain it to them, they may shop it. They might, but my experience is they never do. They usually don't, because once they have confidence in you and they've invested time and money with you, they typically will come back. Rarely do I hear of someone not coming back and trying to implement a plan on their own. In fact, I'm just saying that because I don't believe in being crazy on absolutes, but I honestly can't think in 30 years I've heard anyone take a strategy plan and go off and have somebody else implement it. Mark, anything you want to add to this one, number 7?
Only that you may have noticed that there's an undercurrent in these pricing contexts, or that's actually a term of art. In these discussions about price, there's an unspoken undercurrent that you should be hearing from Steve and me, which is that if you're trying to do this hourly, you're probably not doing it as effectively as you might if you adopted a fixed price model. So implied in everything we've talked about in pricing so far is that you have a fixed price for fixed sets of services and that you're not quoting hourly fees.
Excellent. We could probably do just one webinar on comparing and contrasting the benefits of hourly versus fixed pricing in your practice. So we could definitely spend some time on doing that. Mike, that might be a future topic for us. Number 8, Mark, why don't you take the lead on this one?
Well, I alluded to this earlier about the importance of being yourself when I was talking about the laminated price sheet that, lets me, for example, given my personality, say things like, well, I can't negotiate that price, it's in plastic, and do it in a joking way and get away with that. If your personality type is super serious and you're giving the appearance of very strict, very serious, you should not attempt to tell jokes. They will fall flat, and it'll cause them to question your credibility, which is a roundabout way of saying you need to sell what you are and what you're offering, not adopt somebody else's words, phrases, or even stories because you think they sound clever. If you can't make that work for you, then you need to find something that does. So this is not an effort in finding scripts. It's an effort in finding ways to communicate who you are and what you bring to the table. If you try to be someone else, you'll lack authenticity, and that will be detected by the prospect, and they won't put a finger on it. They won't know exactly what the problem is. They will just know that something is out of line and incongruous, and their gut will say, I can't hire this guy. There's something wrong here.
That is perfect. That is perfect. Look, it is a difficult thing to say, and most of you on the webinar have never met me, but you probably won't be shocked when I make this statement. I do not have the charm or intellect that Mr. Metzger has, nor the sense of humor. Where I have to make up is working hard and being straight with people. And so you really need to figure out what the core personality of who you are, and be that during your initials, and not try and be anything else other than authentically 100% you, and it will come through. They're not coming to you because of your charm. That's probably an initial benefit, but they're coming to you because you can solve a pretty complex problem that scares the fool out of them. And so being yourself gives them confidence that you're going to be authentically you, and you'll take care of them. Number 9, this is one that I am particularly fond of. Mark, would you like to talk about this for a few minutes, or would you like me to play with this one?
Go ahead, and I'll fill in anything else that's left over.
So thanks. So this is really critical, and I think because of how we're trained as lawyers, we really drive by the emotional experience that our prospects and clients are having. This is probably one that it took me a while to learn personally, but once I learned and owned and implemented in my initials, it was kind of a game-changing experience, because a lot of lawyers don't practice active listening. A lot of lawyers don't like to acknowledge emotions. We don't even like to be present to our own emotions. And it's far better for us to be problem solving than appreciating some of the fears and concerns that our prospects and clients have. One of the most powerful ways that you can change the dynamic of your initial meetings is to really, first and foremost, when your prospects start to share with you their fears and concerns, acknowledge them and say, wow, I totally get that you're really worried about your mom losing everything that she has. That's really, I got it. And I really would like you to look at how to acknowledge your emotional experience at the beginning and the end of the meeting. The most important thing that you can probably do is make them feel confident that they made the right decision in hiring you. Nothing can make them feel more confident than making them feel right, smart, and at the right place. And I'll give you an example of that. So, and this will hopefully you guys will, those of you on the call and the webinar with us will appreciate this. The fact that you're investing time, money, or in this case, no money, but the fact that you're investing time and effort and trying to improve your initial consultation is a brilliant thing to do because it will give you a competitive edge in the marketplace. So, there's two elements to this acknowledgement to you as people listening to Mark and I is number one, it's actually true. If you are improving your initial, it will give you a competitive edge. But more importantly, I want you to think about how that makes you feel when we acknowledge you when you're doing this. So if you're having someone set up a plan or someone do crisis planning for their parent, taking a moment and saying, you're doing the right thing for your mom or dad, or you're doing the right thing for your family. And this is the right thing to do, and this is the smartest thing to do based on everything that you've told me. It makes a significant difference for people because they're scared. They're spending significant money with you. They're terrified of, are they doing the right thing? And nothing makes them feel better than a powerful authority position, which you are, believe it or not, telling them you're doing the right thing. This is the right thing to do. And doing it at the beginning and the end of the meeting allows them to have kind of an emotional completeness to this. So it's a very powerful thing. Once I started practicing this in my initial prospect meetings, it was a game changer for me. Mark, anything you want to add to this? Or
well, I think that was brilliantly said when you got to fear. Fear is, I believe, the core of all of this because they all come in with different fears and different stories that they've told themselves. For some people, it's as simple as they fear looking stupid because they don't know the answers to the questions they're asking you. And for others, it's fears about what will happen to their family or their parent or their loved one or whatever. So when you choose to acknowledge their concerns and confront and discuss the very thing that's making them feel fear, even though they may not describe it that way, you come off looking very brave and therefore that much more believable because you're willing to confront the dragon that they brought in.
That's perfect. Brilliant. Number 10, and I'll hit this one briefly because I want to give you a few opportunities to talk to Mr. Metzger if you've got questions. Look, you may spend a tremendous amount of time prepping for a trial or prepping for a hearing or prepping for something. This is the same thing. It's probably the most important thing that your client's going to get to experience. So I'm going to suggest that you script out any key elements if necessary. If you need to, practice. And if you need and you feel uncomfortable talking about money or prices or anything like that, practice it so you can work through anything that makes you feel awkward or you stumble on during your consult. Mark, anything you want to add to that before I jump forward? I'm feeling a little time pressure.
I think that you said it very well. The practice is key, especially on the price. If you're not going to follow our advice and give them a printed price sheet, when you stumble or stammer or you stutter your words when you go to bring out the price or you feel embarrassed about it, that's a signal to the client that maybe there's room here, and then they want to have a discussion with you about how much they're going to pay you. If you can learn to say your price with a straight face and with complete confidence and comfort, what the client hears is, even though they don't process it this way, this is what everybody pays. I'm not getting ripped off.
Perfect. Excellent. Our suggestion on this is that we recommended 10 different things that could hopefully allow you to improve your consultation. What we do is kind of take a risk on these. I know it looks kind of terrifying at first. And you're like, well, you don't understand, Steve. I've been doing it this way for 10 years or 20 years, or I'm new to the business and I have no idea what I'm doing. You got to take a little bit of a risk to make this improvement and to grow. So I would encourage you to, take a swing at least one or two of these ideas. Okay, Mark, I'm going to talk about one thing, and then I'm going to give Mike Wells the opportunity to open up the lines for any questions or feedback that people might have. So I'm going to recommend those of you that are, some of you already committed to doing the practice growth program, and some of you are brilliantly being part of Mr. Metzger's practice growth program. If you're not sure what you need to do to help you with your practice, there's a couple of recommendations that we have, or at least I have. Number one, we have two really remarkable guys that will probably reach out to you after this webinar, and that's Jeff Hines and Larry Wharton. These two guys are part of our customer services team. They're fantastic guys. They have hearts of gold, and every day they get up and their sole job is to try and figure out ways of making our clients' lives better. If they call you and say, hey, what can we do to help? Take the call, because I'm paying them to help you. Their job today is to reach out and see what we can do to help you on this call to make your practice better, because our mission here at the end of the day is not only to help you grow your law firm, but really to help you make a difference for your clients and your family. And these two gentlemen every day get up and work their fannies off to do that. So they're going to call you and really see what they can do to help. I'm going to recommend that if you do take their phone call, that you ask them about how to look at improving your law firm's performance through doing something like a practice growth diagnostic. The practice growth diagnostic really addresses 4 key elements. Number 1, it focuses you on, first and foremost, what your DISC profile is. And Larry and Daniel could talk a little bit more about that. But Larry and Jeff could talk a little bit more about that. The focus DISC advantage is really going to be with either Daniel or Denise, who is part of our customer services team. And it's really about how you like the world to work and how to use that to your advantage. So if you're strong in a particular area, such as analysis, or if you're strong on people skills, how do we organize and put your firm around that strength? 2, it allows you to do an assessment of your practice around the 4 cornerstones, in particular: time management, cash flow, profitability, team development, and client development. Those are critical elements. And then at the end of the call, they're going to really kind of give you their feedback and really give 3 most important recommendations to move your practice forward. The investment to that is very modest. It's $295. And if you go ahead and sign them up 1-for-1 today, you can either do it through Larry or Jeff, or you can go right to the atticusadvantage.com website and click the Get Started button that this big yellow arrow is highlighting, and register for one. If you do that today and you do it through Larry or Jeff, or you go through the website and do it, and you reference today's webinar, we're going to give you a gift. We're going to give you the Time Management for Attorneys book, which my partners Mark Powers and Sean McNallis wrote. And this is probably the best-selling book in the legal space on time management. You know, most of the lists that track book sales for lawyers on like how to grow a practice, this is typically number 1 by most rankings. So if you don't have this book, it's included. It's about $90. It's included in the price of doing the practice growth diagnostic. So that was a direct suggestion. If you haven't taken advantage of doing a practice growth diagnostic with us, I'm going to strongly recommend that you do that. My biggest fear for you is I don't want you to fall for what we call the 90-day think about it plan. And the biggest challenge that we have as lawyers is that we're intellectual creatures. And if we don't understand something, or something scares us a little bit, or we're uncomfortable with something, we have a tendency to think about it. And think about it is the most creative form of procrastination that I can ever think of, because it allows you to intellectually defend, well, I'm still thinking about this. You're not going to grow the practice without taking an action. And you're usually going to have to invest one of 2 things, if not both: money and time. And you're not going to get growth unless you put money and time at risk. It doesn't happen that way. You can think about it all you want, but without investing money or time, you're not going to get the outcome that you want. Mark, I don't want to take too much more time about that. Mike, why don't we go ahead and open up any questions that people have? We still have a considerable amount of people on the webinar with us today. So if anyone has a question, Mike, why don't you talk to them about how to ask the question?
Absolutely. There are a couple ways you can do that. Again, you can chat your question into the dashboard, and if you'd like your question to remain anonymous, please indicate so in your message. You can also click the hand icon on your dashboard to indicate that you'd like to ask your question aloud, and I'll call on you and I'll unmute you so that you can be heard by everyone. Steve, we do actually have 4 questions that have already been sent in. So I'm going to start out with one from Meg. How do you have an engagement letter ready for the first meeting when you don't know exactly what they will need?
That's a great question. Mark, you want to take a swing at that, or you want me to?
Well, I have a real quick answer, and then you can add on to that. My answer would be you have a general idea of what the engagement is and the type of work that you do. I would not expect that you're going into an initial in an estate planning practice, for example, and be willing to take on a personal injury case so that you wouldn't have an engagement letter ready. So you can have an engagement letter that's ready to go. You already know the person's name. You got that when they made the appointment. Nobody says that the engagement letter must be all typed out in the same typeface. There's nothing that says you couldn't, for example, have a price list that's on the back of the engagement letter, and you'll circle the items that make sense with what you're recommending to the client be done, and then add those up on the bottom of the price sheet to a handwritten total, and then have a blank on the front page of the letter where you write in the amount that's to be done, and the text of your engagement letter says the circled items on page 4 are attached. Describes the scope of the engagement.
That's perfect.
Right.
That's perfect. The other way of looking at that is that your assistant or your client services people should be pre-qualifying that prospect before they come in. So you should have at least some. The more sophisticated you become in your practice, the more you can pre-qualify prospects, and the more you pre-qualify, the more you can tighten what your pricing is going to be during initial. So there's some things that need to occur in the prospect pipeline to improve that. But it's a great question. Mike, what's number 2?
We've got one from Carla, and her question is this: Is giving the agreement for the client to take versus signing at the end equally as good? Ours is long, and we represent people 2 ways, hourly or contingency, and it often depends, so does the trust amount, on what makes sense for the case and for the firm.
Personally, I would walk the client through the engagement letter before they left and try to get it signed before they left. In my experience, clients that walk away with an engagement letter to think about it are in the Think About It program that Steve described, and you're going to engage a lot fewer of those people than you are ones you get to sign the letter before they leave.
That's excellent. I would also invite you to look at your long, complex engagement letter to see if you can simplify it. My experience is that sometimes, because I started out this way when I was trying to do everything I could to protect my firm and protect other firms, but sometimes have a friend look at it, or if you're in one of our programs, have one of your colleagues in the program look at it and say, look, can you cut this in half? If you could cut this in half, how would you do that? Or you can find a gifted writer. I mean, Mike Wells, who's on our team, had a remarkable career as a professional journalist, and his ability to take some of the gobbledygook I write and make it look sensible and short and concise always amazes me. So, as a lawyer, we have a tendency to be overly wordy, as I'm doing right now. I would invite you to look at how to synthesize that quicker and more concisely. Okay, I'm gonna stop there. Mike, what do you got next?
Well, first of all, thank you. But we have several more questions that have been sent in, so I want to get your permission from both of you. If you have a couple extra minutes to go past the hour, these are great questions, and I think they could be helpful for others.
Fine with me.
I think I'm fine with that. Yeah.
Okay, great. So the next question comes from Linda, and she says, since Symposium, I've been thinking about pricing structure. Doesn't necessarily matter what others are charging if we are structuring our prices on what we have seen as a time spent on plans and what we value and what value we see that we bring.
Might be missing the question, Mark. Did you get the question?
I didn't, but I was going to say that as a general proposition, I would agree with that as a statement. That's where your thinking needs to be going.
Yeah.
I think the main part of the question is, does it necessarily matter what others are charging if we're structuring our prices on what we see as the value?
Yeah, my experience is that since other lawyers are seldom engaging you, it doesn't really matter what they're charging.
Yeah, and it's perfect. It's brilliantly said, especially if you have a strong referral-based practice, because most of the time in a referral-based practice, they're not shopping. So the more that your practice is referral-based centric in your marketing, the more you can get, you can dive deeper on unique pricing strategies because they're not really shopping. Most of the price competition is usually in our heads, especially in a referral-based practice. So that's excellent. All right, Mike, what's your next one?
Do you recommend charging for a non-lawyer consultation?
Whew, this one is, so there's 2 parts to this. One is I would recommend, and Mark, you jump on this when I'm done kind of kind of babbling about this. There's two parts that you need to go through to set up a non-lawyer initial. First, you need to make sure the 5 Ps are handled in that meeting so that your non-lawyer can do those. And two, prior to the non-lawyer initial, there needs to be a conversation that we call the comprehensive consult model, where you're setting up a choice context between offer A and offer B. Offer A is to meet with the lawyer for $750 or meet with the non-lawyer at no charge. Now, I'm really simplifying that tremendously. It's something that we work probably around a year on with a lot of our lawyers in the Dominate Your Market program. We kind of take it apart at every quarterly workshop so they can lay the foundations to go for that. So I would say no on the non-lawyer initial if you're doing a comprehensive consult model where you're trying to drive the prospects away from the senior attorney or the initial lawyer into a non-lawyer meeting. Mark, what would you want to say to that? Because that's like a 3-hour conversation by itself.
I think you said that perfectly. There's nothing to add.
Okay, great. What do you got next, Mike?
Okay, here's one from Douglas. If I have a range of prices on the pricing sheet, what prevents the client from asking for the cheapest level?
Great question. Mark, you want to take a swing at this one?
Steve made an allusion to one of the things we've been working on in the Dominate Your Market program, and that was the reference to a pricing context, which is an effort to exactly manage precisely that issue in that question, to present the prospect with 2 or 3 or maybe 4 in an extreme case options for them to choose among that make clear to them what the effect of choosing those is. And there's a lot of psychology and a lot of theory that goes into how you build the pricing context and how you construct it in such a way to drive the client toward the situation that makes the most sense for your law firm and the way it's set up to work, but at the same time offers the flexibility of saying, from time to time you'll have one of these things set up and you may say to the client, you really belong over here in the lower end of things. You don't need this and you don't need that. I have more than once in a pricing context discussion with a client sold against the most expensive option on my price sheet because it bought me credibility that I wasn't trying to sell them that. There's lots of different issues there.
That's well said. One of the more fascinating things is that it's one thing to have a price sheet and has a lower price point, which I think is a really good concern, Doug. It also has a lot to do with how you explain it. So you can, just what Mark said, you can actually use things on your price sheet and move the client up and down on the price sheet based on how you explain and how you help analyze their situation. And you can say things like this, well, based on your scenario, I would probably be inclined to push you towards this level. My concern with taking you down to the basics is it doesn't address the 3 core issues you talked about. You talked about, inheritance protection. You talked about disability protection. You talked about, protecting your home from nursing homes. The basic really doesn't do any of that. So I think we have to move you up here towards this price point. Would that be okay with you? So you're using permission or asking the client if they're comfortable. So I think that would be a critical component of that. So you have the price sheet, and kind of learning how to guide the client towards what's the best fit for them. So that's a great question. These are good questions, Mike. You're right. You got anything else?
Yeah, I've got a few more, and I'm going to recommend that we just do one final question. The rest of these questions that folks have typed in, if we did not get to you, please know that Larry or Jeff will be reaching out, and we're going to make sure that your question gets answered. We'll get the response from Steve to send back to you. But here's the last question I want to put out to you. Would you recommend a non-lawyer discuss price and sign an engagement agreement at the initial consult before the attorney meets the client at the separate design meeting?
Let me say, if I've got the assumptions correctly, so in this case, the non-lawyer sets the price according to the price sheet that you have provided them. So the pricing is set by you first and foremost. The non-lawyer doesn't have discretion to, wing a price quote. It's got to be set by you, and there's got to be a pricing model or a price sheet set by you. They don't have discretion to move all over the place. 2, they may give you a check and sign the engagement letter, but when you come in to see them, you're making clear that that's the formal acceptance of the client as an official client. My experience is that most firms that Mark and I have taught this strategy to, and most firms, because I use this strategy in my practice for 15 years. Most of the time, the non-lawyer, you're not taking some, you're taking a really well-trained, you're probably going to spend 3 to 6 months to teach them how to do the meeting. You're going to make sure that your pricing's down. You've got to make sure that your process is down. And most of the time, my experience is a well-trained non-lawyer will do better than most associate attorneys will do in that process. So I would say yes, with the following caveats that I'm testing your assumptions in that question. So with that, Mark, thank you so much for joining us. I greatly appreciate your time.
Thank you, Steve.
Those of you that are working with Mr. Metzger and his practice growth program, congratulations, you're in for a treat. I don't think I would, I can say that with great confidence that there's no one that's going to work harder, or no one that prepares more, and no one that thinks more about these topics to really figure out how to make a difference for you in growing your practice through the practice growth program. Those of you that are not sure what you want to do, give yourself a great investment or a Christmas gift and take advantage of the practice growth diagnostic and talk to Larry or Jeff, who are just phenomenally great people. They've been with us for a couple of years, and they're just phenomenally great people that are committed to you taking your practice to the next level. So if you have the opportunity, by all means, when they call you, talk to them, or just go to atticusadvantage.com and register for a practice growth diagnostic. You'll get an opportunity to talk to Denise and Daniel, who are equally great and committed to trying to figure out what we can do to support and help you grow your practice. Because we know at the end of the day, you having a phenomenal practice allows you to make a phenomenal difference for your clients. And that's really what we're all about. That's what we've all committed to do as lawyers. With that, Mike, is there anything else you'd like to add before we call it a day?
Just to let folks know that we are, of course, recording today's session. So if you wanted to listen to it again, we'll reach out to you to give you the opportunity to stream that recording from our website. And thank you, Steve, and thank you, Mark, for leading today's session.
Thank you, everyone. Have a great day.